The Constitution does not contain any specific provision declaring the equality of the sexes. Although the 14th Amendment contains the Equal Protection Clause and a Privileges and Immunities Clause, it has been interpreted to apply most directly to race because it was a response to slavery and the Civil War. Some 19th century cases, for example, held that only men possess a constitutional right to pursue a chosen occupation or to vote in state elections. The court's language in Bradwell v. State, decided in 1873, reflects the sexism of its time. Man is, or should be, woman's protector and defender, the court proclaimed, and the natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. Throughout the 19th century, however, women's roles already were changing. The Second Great Awakening, a populist religious revival that ran from the late 18th century to the middle of the 19th century, often featured women as leaders and sometimes even as preachers. The evangelical fervor of the Second Great Awakening encompassed social reform movements, including temperance, abolitionism, and in some quarters, women's suffrage. Women held prominent leadership positions in both the temperist and abolitionist movements, so it is not surprising that many women began to advocate for the right to vote. The 19th Amendment, prohibiting the denial or abridgment of the right to vote on account of sex, was not ratified until 1920. The court has interpreted the 19th Amendment narrowly to apply only to the voting franchise and not to broader related rights against discrimination, for example, in jury service or state-licensed occupations. In the early 1970s, there was a push to adopt an Equal Rights Amendment, which stated that equality of rights under law cannot be abridged on account of sex, and which would have authorized Congress to enact implementing legislation. The amendment fell 3 states short of ratification. Around the same time, cases in the court tried to press for the recognition of sex discrimination under the 14th Amendment's Equal Protection Clause. In Reed v. Reed in 1971, the court implied a kind of heightened rational basis review to find that a statute arbitrarily differentiated between men and women. In Frontiero v. Richardson in 1973, the court sustained a challenge to a federal law affording male members of armed forces an automatic dependency allowance for their wives, but requiring service women to prove their husbands were dependent. A plurality led by Justice Brennan would have identified gender as a suspect classification subject to strict scrutiny. Employing a political process analysis, Justice Brennan noted the history of sex discrimination in the immutability of sex as a characteristic, in a time it could be noted when concepts of gender fluidity were not as understood as today. Although Justice Brennan acknowledged that women were not a discrete and insular minority, since women comprise about half the population, he noted the history of underrepresentation in the political process, since women did not have the vote before 1920. In a concurrence, however, Justice Powell said the case should be decided under the heightened rational basis review used in Reed v. Reed, at least prior to what then seemed the imminent ratification of the Equal Rights Amendment. Of course, the ERA was never ratified, and so there was no majority in favor of extending suspect classification status to gender distinctions. The question of how to classify gender distinctions came up again in Craig v. Boren in 1976. The factual background of this case is a bit odd. In the mid-1970s, there was a marketing craze for near beer, that is, beer with a low alcohol content. Oklahoma adopted a statute that allowed 3.2% near beer to be sold to females over the age of 18 and to males over the age of 21. This upset some good old boys between the ages of 18 to 21 who wanted permission to drink near beer with the ladies. Certainly this is a case that could only have arisen in the South. This time, Justice Brennan garnered a majority, not for strict scrutiny, but for intermediate scrutiny, constitutional near beer. The court held that gender-based classifications must serve important or substantial government objectives and must be substantially related to the achievement of those objectives. Gender cannot be used as an inaccurate proxy for other more germane bases of classification, and outdated concepts of gender roles do not promote valid justifications. Here, the majority held data on gender differences in DWI stops were not sufficient to distinguish the drinking age for near beer because the statistical fit was tenuous. Justice Rehnquist dissented. The main point of his dissent was that the majority invented the intermediate scrutiny standard out of thin air. In the years after Craig v. Boren, the court moved towards an even stronger form of intermediate scrutiny, evidenced in Mississippi University for Women v. Hogan in 1982. requiring an exceedingly persuasive justification for gender-based classifications. This standard was adopted in 1996 in a majority opinion written by Justice Ginsburg in United States v. Virginia. That case struck down the exclusion of women from Virginia Military Academy, a prestigious public military college run by the state of Virginia. In reaching this holding, the court rejected Virginia's two justifications for maintaining the male-only academy. First, Virginia argued single-sex education provides important educational benefits and contributes to diversity in educational approaches. In response to this argument, the court did not question the state's interest to further even-handedly diverse learning opportunities, but noted that the opportunity to attend VMI was unique because of the school's particular character. Second, Virginia argued, VMI's unique method of character development and leadership training, called the adversative method, would have to be modified if VMI admitted women. In response to this argument, Justice Ginsburg stated, "The notion that admission of women would downgrade VMI's stature, destroy the adversative system, and with it even the school, is a judgment hardly proved, a prediction hardly different from other self-fulfilling prophecies once routinely used to deny rights or opportunity." Finally, the court also rejected a proposed remedy of creating a separate all-women's institution, which the court said would not provide an equal program or equal opportunities to VMI. In a dissent, Justice Scalia complained that today the court shuts down an institution that has served the people of Virginia with pride and distinction for over a century and a half. According to Justice Scalia, the long tradition of male-only combat military service and government-funded male military schools supported VMI's position, and the assertion that this tradition has been unconstitutional through the centuries is not law but politics smuggled into law. Finally, Justice Scalia claimed the majority opinion abandons intermediate scrutiny for a form of strict scrutiny. As U.S. v. Virginia suggests, the court has repeatedly wrestled with cases involving statutes or rules based on inherent or perceived differences between the sexes. In 1974, in Getteldig v. Aiello, for example, the court upheld an exclusion for disability benefits for disability that accompanies normal pregnancy in a California disability insurance program. The court found that this exclusion did not discriminate based on gender as such because the program divided potential recipients into two groups, pregnant women and non-pregnant women. In Michael M. v. Superior Court in 1981, the court rejected an equal protection challenge to California's statutory rape law that punished the male but not female participant, where the female was under 18 and not the male's wife. The court stated that the gender classification was not invidious, but reflected the fact that the sexes are not similarly situated in such sexual relationships, for example, because of what the court deemed a natural deterrent effect for women, since the significant harm falls on women via an unwanted pregnancy. In Rochster v. Goldberg in 1981, the court rejected a challenge to the exclusion of women from the required registration for the draft, citing deference to Congress in the area of military affairs and the then existing statutory exclusion of women from combat positions. In Cabin v. Mohammed, a 5-4 decision in 1979, the court invalidated a New York law granting the mother, but not the father, of an illegitimate child the right to block third-party adoption by withholding consent. And in Wen v. INS in 2001, the court upheld a federal law that granted automatic citizenship to a child born to a citizen mother and a non-citizen father, but requiring other conditions to be satisfied if the father is a citizen and the mother is not. The court based its holding on what it considered significant difference between a mother's and a father's relationship to the potential citizen at the time of birth, as well as on a government interest in requiring proof of paternity. Recently, in the 2017 case of Sessions v. Morales-Santana, however, in a majority opinion written by Justice Ginsburg, the court held unconstitutional under intermediate scrutiny a statute concerning the U.S. citizenship of a child born abroad to parents of mixed citizenship. Under the statute, if the mother was a U.S. citizen, the father was not, and the parents were unwed, the child born abroad would receive U.S. citizenship if the mother had lived continuously for at least 1 year in the U.S. prior to the child's birth. However, if the father was a U.S. citizen, the mother was not, and the parents were unwed, or in any case if the parents were married, the statute required the U.S. citizen parent to have resided in the U.S. for at least 5 years continuously prior to the child's birth. In other words, the statute contained an exception that lowered the continuous pre-birth residency requirement for unwed U.S. citizen mothers. Justice Ginsburg stated that the statute reflects the old view that, in marriage, husband is dominant, wife subordinate, but an unwed mother is the natural and sole guardian of a non-marital child, and the alien father who might transmit foreign ways was presumptively out of the picture. Justice Ginsburg considered this view stunningly anachronistic. Nevertheless, although the statutory distinction was held unconstitutional, the court upheld the statute by striking the exception for unwed citizen mothers. As the discussion of this case in the supplement notes, this was the first instance in which the court, having found unconstitutional gender stereotyping favoring women, chose to remedy the inequality by leveling down rather than leveling up. As these cases illustrate, in addition to determining the appropriate level of scrutiny for gender classifications, it can be difficult to discern how to apply intermediate scrutiny when a statute or rule makes a gender-based distinction based on some inherent or perceived difference between the sexes.